Russia and America are not getting on very well at all. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing, you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the president now and the deputy president do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Rachel and the wife of Androcas. Rachel and Androcas were great friends. Somehow they were very happy that you could see two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is civilization we want. That is the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission, Mr. Lord Eric Ogola, who is you are presiding over the bench, please come up with a judgment or come up with a ruling that you are not going to lift these conservatory orders. If you do so, you will be opening a chapter for this country which we may not be able to handle at all. Currently, let me remind you again, the deputy president is enjoying poll rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the parliament or National Assembly, which actually impeached the deputy president, if you go through what happened, was a disaster, was disappointing. It is not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, Madam?
Please wind up the submissions.
I'm winding up. I'm winding up. And I'm winding up on this note. My lords and my ladies, I have lived enough in this country, I've lived long enough in this country, and in particular in Nairobi. When you hear a rumor, do not be so small-minded and dismiss the rumor at all. The rumor usually has got some truth. So that when you hear Paul Mwita has been bribed, don't dismiss it quickly. There may be truth in it. When you hear Kibe was seen with so-and-so, don't dismiss it very quickly. There may be truth in it. This is the ability that Justice Martin had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and the Bishop still controls the country. It controls Parliament. It controls Senate. Let it not be said it controls Judicial. Thank you.
May it please you, Lord President of the Court, the members of the Court, we are happy to reply to our colleagues. Somebody has come from the movie.
My name is Paul. I'm here for Sharia alongside John Marie. Sorry.
Sorry, my lords, I'm on high demand. So I beg to leave the court. I'm going to give to some other matter.
Just a clarification, when the judiciary was enjoined, last time Dr. Amino made an application for the judiciary to be enjoined, and then you enjoined
My name is Mosongo. I proceed. Thank you so much, Your Lordship and Your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my few minutes. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that their right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that Your Lordships and Your Ladyship, to ensure that their constitutional right to fair trial, even including during this process, just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies.
Yes.
My apologies. My apologies. Your Lordships and Your Ladyships. Your Lordships and Your Ladyships. If I may proceed, it is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because you know it said ukiona cha mwenzako, kichwa cha mwenzako kimeinuliwa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, Your Lordships and Your Ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the Lordships and the Ladyships to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice was not served. It's imperative that at all times justice be seen to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm will be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their rights before the final outcome of this honorable court. I humbly pray that your lordships and your ladyships, please do not vacate the orders. Thank you so much.
Thank you very much, presiding judge and the members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. And that's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Rigathi Gachagua, by dint of Article 157, sub-Article 7. It is important for us to go there, my Lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. That's the language. Shall cease to hold office. As at the day and the time and the minute that Senate voted, the Deputy President ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kemodo of Teresia Kemodo and Company Advocates, who wants an apology. The Deputy President ceased to hold office. But something else happened. An intervening fact is that on Friday the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. And that was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. And the logic of the law, we've been told a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity when the Constitution has said, shall cease to hold office? It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So that his lawyers may be acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in these circumstances. At 1:31 p.m., when the conservatory orders both were issued, both in Kerugoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench. And you said, there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this Constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this Constitution to nominate a deputy president. He did that. He has a power to send that name to court, to Parliament. He did that. Parliament has a power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the conservatory order that came from that came from Kirogoya. Is that Kirogoya? Yeah. A place called Kirogoya. We were told, my lord, and this is true, that the impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. That is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that a vice president will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sits as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is here. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kiriro Ngugi, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kiriro Ngugi is instructive. This is what the court said, and I'll be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the ripeness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. It's thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it, but it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions, and each institution should keep to its lane. We have developed a constitutional law, or we are developing a constitutional law here that actually invites contravention of the Constitution, and it is this: that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go to my second last point about I want to take you to the case of County Government of Kisii and two others versus the Independent Electoral Commission. It is a 2024 decision, and this is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bang her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the deputy governor shall remain vacant indefinitely for whatever reason. Having so held, that gazettement is a mere administrative formality, and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kisii was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the Deputy Governor of Kisii. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our constitution has self-correcting provisions. What happened there, my lords will remember, yes, is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kiba Mungai, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest is in continuity. Thank you.
Yes, my lord. Your Lordship and my lords, let me dive right into my submissions, and I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25(1)(c) on the right to a fair hearing, were complied with. And I will show, my lords, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, had voted by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged, then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either exercise their power directly or through their elected representatives. So my lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented this case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body. Each senator, considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My lord, then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my lords? That was accorded, my lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my lord, he was present during the entire presentation of the case by the National Assembly. But third, my lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this. At 5 p.m., my lords, the Deputy President, the counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Karen Nostrum. He neither presented a medical report nor a report from any doctor.
Nothing.
And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my lord, counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my lord? Perhaps they did not read the wording of the Constitution and all the standing orders. because a party, my lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my lord, every opportunity was presented to the respondents to present, but they opted, my lord, not to proceed and not to provide any document to Senate at that point to, my lord, confirm, my lord, at the point that their client or the deputy president, in that matter, was unwell and admitted. Senate then proceeded, my lords, to vote on that question. My lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disaster. My lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the deputy president. My lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend Mr. Masharia made before this court, that there was additional evidence that was entertained by the speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my lord. My lord, that was a substantiation of a charge on economic crimes that failed. Only, my lords, 5 out of the 11 charges proffered against the deputy president petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the deputy president was convicted on the gross violation of Articles 10(2)(ab), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my lord, that is on violating his code that requires him to undertake certain functions and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the deputy president to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority It is a clearly.
In yourself.
And I was thinking, Professor.
My Lord,
Professor Miyagi.
in the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest. That this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the deputy president, my lords and my ladies, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a deputy president sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect Meru. This court would only use that authority to support the appointment of His Excellency Honorable Professor Rigathi, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. My Lord, wherein would his remedies lie? My Lord, friend, your body will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week's salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary damage. But this country, my Lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My Lord, if I move to the other point, my Lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my Lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my Lord, because the authority in my movie Sonko and Nairobi City County Assembly, and again I argued this one, my Lord. In fact, I was in this matter. In this case, my Lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stated that 1, there was the Hansard that contained reasons. 2, my Lord, in terms of an impeachment, my Lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my Lord, that that is an option that is open to Senate, and cannot speak to the lawfulness or otherwise. Counsel on the other side submitted that there was need for a committee. Senate, in its proceedings, my lord, in its wisdom, had voted to proceed through the whole house and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My lord, we submit, my lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lord. Thank you.
My lord and my lady, my name is Modomi Diankolu for the second interested party, and to that end we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have, in addition to that, filed a list and battle of authorities on that preliminary objection, and that list and battle is dated the 25th day of October 2024, and pursuant to your directions, those are the battles, my lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have, in addition, filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I had forgotten to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO, and you find that I deserve to be laughed at, it's okay. My lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution, to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the President and the Deputy President. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the President or the Deputy President of the Republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the President and the Deputy President. But if we are wrong in that submission, my Lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My Lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this: that our Constitution denies this court, the High Court, jurisdiction on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My Lord, it is clear by dint of Article 58 sub Article 5 that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngwe, talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear: if you have a dispute as to that matter, never mind it has abrogated the entire Bill of Rights, the court you go to is not the High Court, it is the Supreme Court. My Lord, property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not without more mean that this court as jurisdiction to hear that matter. In other words, my lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gidhu Muige's issue about justiciability, then you have no jurisdiction. Luckily, my lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my lord, the Bado of Authorities. We have produced you, or rather before you, extracts of the Boma's constitutional, the Boma's draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one, A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Boma's process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course we know, my lord, the Boma's draft was one of many. The next draft that was generated in that process is at page 7 of our Bado, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-Article 4, that the Supreme Court has, paragraph A, exclusive, underline exclusive. We move from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was a work draft. We have produced it at page 10 of our Bado. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is the draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there will be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144, yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our Bado. My lords and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you, 144, Article 144(8) of our Constitution, is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144(9). And when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the $1 million question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction, and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be free. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my lord, we are told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojeda is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My Lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my Lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years now and counting. Why this decision is important, my Lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you check the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my Lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life, to the extent that he refused to resign, it meant the US Treasury was bound to continue paying his salary and emolument while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives, and the Senate took up impeachment and impeached this judge. But when you follow the holdings in this case, my Lord, they say at page 20 of Wabadu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said, following this decision, that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US, the Supreme Court of the Republic of Kenya. And my Lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General Emeritus Professor Muigai, if you go to page 21, my Lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached, to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my Lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our BADO. And the reason I'm referring it to you, my Lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable. But there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make heavy weather of the idea that this type of dispute is not justiciable. Lastly, you were told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our BADO. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my Lord, when all is said and done, is to do either of two things. Hold, you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you.
Once you use that, we have to use it for that. Yeah. We can use it for that.
My Lord, my lady, if it may please you, my name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation. The second issue, my Lord, I'll be addressing you on is fair hearing, with reference, my Lord, to the National Assembly. And lastly, on the nominee, my Lord, the Deputy Presidential nominee. My Lord, on the first point of public participation, you shall note first, my Lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my Lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my Lord, dictated by Article 118B of the Constitution. And, my Lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my Lord, to refer to the Supreme Court BAT decision. And specifically, my Lord, at page 45 of that decision, which we have attached, my Lord, to the first Respondents supplementary list and bundle of authorities, dated 28th of this month. My Lord, the second authority that I will refer you to on matters public participation is the recent authority, my Lord, that was rendered last week by the High Court in the affordable housing decision, my lord, that is petition number E154 of 2024, and specifically, my lord, at pages 178 to 179, rather to 184 of that decision. My lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my lord, has been undertaken in the history of this country. And my lord, I will refer you to the annexed public participation report, and specifically, my lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my lord, very quickly, you'll note that over 224,000 people my lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My lord, I'm trying to establish the fact that heavy weather was made, my lord, on the fact that there was no public participation.
We have those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before you court. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my lord, I stand guided, and then that.
In other words, Mr. Milimani, you may spare us the submission on the sufficiency of the public participation.
Correct, my lord. Yes, my lord, I stand guided, and I was just going, my lord, to refer you to one authority that we had, my lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my lord, the sufficiency or otherwise of public participation, my lord, is to be determined at the main trial. And my lord, therefore, I would agree with you that all I need to do, my lord, is to refer you to the report that I've indicated, my lord, that it appears at page 427, specifically the findings, my lord, to 455 of the replying affidavit. But my lord, allow me just to pick one thing out of that report. You are particularly, my lord, referred to one of the constituencies, specifically, my lord, Keio South constituency, where my learned colleague, my lord, raised issues that indeed the figures did not tally. My lord, first, you shall note that the figures that were quoted by the petitioners, my lord, are contained nowhere in the public participation report that have been submitted before you. My lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My lord, Keio South views, my lord, are submitted, are to be found firstly at page 289 of the report, my lord, and it appears as item number 95. And this goes specifically, my lord, to the hand-delivered and email views, where it was indicated that, my lord, there was a total of 465 responses, and out of those, my lord, 455 were in support. That is what, my lord, is contained in the report as the first limb. The second limb, my lord, is for those who participated in the public hearings of the 4th, my lord, of October, and is found at page 331. Same Keio South constituency. And my lord, it's indicated that a total of 355 people did, my lord, attend that public hearing. And out of those, 352 persons, my lord, supported the motion. Lastly, on that point, my lord, is to refer you to page 440 of the replying affidavit, my lord, where you shall note, not 440, my lord, I'm sorry, page 439, where, my lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my lord, in support were 807. So, my lord, the views are submitted, or the submissions are submitted by my lord and colleagues, my lord, do not find any favor in the report, and therefore, my lord, I'll urge you that you do ignore them. My lord, I also need to point out that public participation, my lord, is not a referendum. As well understood, my lord. And that in the words, my lord, of your learned brother, justices or sisters, my lord, in the affordable housing decision, public participation does not, my lord, necessarily mean that everyone in the country must give their opinions. My lord, that is paragraph 175 of the affordable housing decision. And that, my lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my lord, to submit their views. And my lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my lord, we shall demonstrate before you that there's absolutely no arguable point, and the public participation exercise that was conducted, my lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my lord, that elections are conducted at the polling stations. My lord, that submission is not true. The presidential, my lord, elections are provided for in terms of being conducted, my lord, at Article 138(2), where it states, my lord, that the elections are at the constituency level and not at the polling station. My lord, the other issue that arose from the submissions from my Iranian colleagues is whether, my lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My lord, my answer to that is simple. That first, my lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my lord, that that response could have been availed to the public. Secondly, that, my lord, the National Assembly only avails what is in its possession. And therefore, at that point, my lord, the National Assembly could not have been accused of not, my lord, presenting to the public what had not presented to it. But more important, my lord, there is no legal requirement, and none was cited by our learned colleague, that dictates that the National Assembly had a duty to present, my lord, that response to the public during public participation. And last, my lord, nothing stopped the first petitioner, my lord, from himself presenting that response to the public, as he did, my lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my lord, on public participation was whether, my lord, the Senate ought to have conducted the public participation exercise. And, my lord, my answer to that is this, that under Article 118(b), my lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And my lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my lord, to undertake the public participation exercise.
We only entertained you on these submissions because we had entertained the people earlier. That's the only issue we are listening to.
I thank you, my lord. But I'm winding up on that, my lord.
You made your point.
Yes.
You made your point.
My lord, the second issue that, my lord, I'll invite your attention to is on the subject, my lord, of fair hearing. My lord, and on that limb, there was a challenge, my lord, to the standing orders of the National Assembly. My lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my lord, and that at this stage, being an intellectual stage, this court, my lord, has no power to invalidate those standing orders, my lord. In the fullness of time during, my lord, the main hearing, we shall demonstrate to you that those standing orders, my lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my lord, is to implement those articles of the Constitution. The other issue, my lord, that was raised was about impartiality of the Speaker, the National Assembly, my lord.
No, Milimani, he's not indicating that we should argue the petition. Let's confirm.
Yes, and my lord, you shall note that the Speaker of the National Assembly, my lord, has no vote in the proceedings, and that is, my lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my lord, is not a valid submission. And my lord, more importantly, my lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And my lord, he did file a substantive response to the notice of motion. And more importantly, my lord, he was given 2 hours to present oral representations. That opportunity he took, my lord. And therefore the question of there having, my lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My lord, my last point is on the nomination, my lord, of my good teacher, Professor Kindiki. And my lord, the issue was whether there ought to have been, my lord, an approval process at the National Assembly, and whether, my lord, there ought to have been public participation, as well as, my lord, the timelines that were invoked, my lord, to process the good professor. Yes, my lord, all I need, my lord, to bring to your attention is there was a ruling, my lord, by the Speaker of the National Assembly that we attached to the first Respondents supplemental list and band of authorities, dated, my lord, the 28th of October this year. And my lord, you shall note that in that communication, the Speaker did address all those issues, my lord. The communication, my lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, Lord, to refer to it when you retire. My colleague, Mr. Macharia, my lord, on a light note, told the court that, my lord, I would have said Weta Tosha. My lord, I'll say that in 2032 when the right comes.
Yeah, the time comes.
I thank you, my lord, unless your lordship have any questions.
Thank you.
Article 148. Article 148, subarticle 1 reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at subarticle 2 that for purposes of clause 1, there shall be no separate nomination process for the deputy president, and article 137 1B shall not apply to the candidate of a deputy president. What then do we read from that? It means that simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that is what happens, we don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of a president, Article 132, subarticle 2, under the functions of a president, the Constitution says, the president shall nominate and with approval of a National Assembly appoint or may dismiss A, cabinet secretaries, B, Attorney General, C, the secretary to the cabinet in accordance with Article 154, and the principal secretaries in accordance with Article 155. It is in that instant that public participation is called for. So that then, when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that will be presented before you this nomination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of a president, the Speaker of the National Assembly shall act as the president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of a deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my lady, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like kufa dereva, kufa makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country, and we know that, as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. My lords and my lady, is that a position we would want to allow the country to get into? Permit me to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses this, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process, so that then the competing interests are balanced in a way that ensures the stability of the country. And because they're deep, it's very interesting and very, something to be very proud about to be Kenyans today, that we are talking about such sensitive issues in this sort of a civil environment. My lord and my lady, in other places, when we talk about this sort of transitions, these are constitutional transitions, and are subjecting the populace to difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? My lords and my lady, the Constitution, constitutionalism, speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure that there is stability within the country and the country is given an opportunity to move on. My lords and my ladies, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then, in its implementation, that social engineering is supposed to help to bring stability within the nation. My lords, my lady, it only follows that for us to achieve that stability, then the orders that were issued and that there are ex parte are orders that are supposed to be set aside. The country allows to move aside. I am most glad.
My Lord the Presiding Judge, as I settle down and begin to make my submissions in opposition to the notices of motion before you, may I kindly request the court to ask that that light, which is a bit blinding, be either angled further up or turned off completely.
The light has hung.
I guess that makes it a smart light, my lord. It can understand and react. My lord, the applications before you for conservatory orders this evening are opposed. For the record, I am Paul Nyamodi. I am on record together with Mr. Gumbo for the second respondent. And my lord, I wish to commence my submission by saying that the task before you this evening is a rather simple task. Listening to my colleagues making their submissions, one would be forgiven if they formed the impression that what was for hearing before you was the petition proper. It is not. What is before you for hearing are two applications for conservatory orders. And my lords, it is my submission that the criteria, which you will no doubt consider when you retire to consider your decision in this matter, is straightforward. Is there, do the petitions before you disclose inherent merit? Would those petitions be rendered nugatory if the conservatory orders that are sought are not granted? And lastly, and most importantly, is it in the public interest to grant the conservatory orders that are sought? I wish to state that the purpose of a conservatory order, or the ultimate beneficiary of a conservatory order, is the court, and not the party that seeks the conservatory order. I say so because the purpose of a conservatory order, my lords, is to preserve a situation so that the orders of the court upon conclusion of the hearing of the petition are efficacious. That is not achieved by returning anybody to office. That is merely achieved by maintaining a certain status quo for the benefit of the court. So anybody who seeks to persuade you that they can be returned to office by a conservatory order, then perhaps has misunderstood what indeed a conservatory order is. My lords, just to pull the strands together from the submissions that have been made by my learned colleagues for the respondent, and the context in which I urge my lords, my lady, to view those submissions, is that they have spoken to the first ground. They have spoken to the first ground in Peter Munya. They have spoken, or they are responding to the question, is there inherent merit in the petitions that are before you? All the submissions about public participation, all the submissions about the Article 50 rights are all in an attempt to persuade you that there is no inherent merit in those petitions. And I don't wish to go back on those, but I wish to just put two issues before you in respect of the question of inherent merit. My lords, my lady, when you retire to consider your decision in this matter, I'm sure you will need no reminding that the issue of, or a merit review of the impeachment process is beyond the ability of this court. So reject any requests from the petitioners to conduct a merit review of the impeachment. What this court is able to do, and I believe that is the decision of the Supreme Court in Sonko, is to carry out a process review. And so that you are, so I then submit that in determining whether there is inherent merit, this court must then constrain itself to carrying out a process review. My lords, my lady, the second point I wish to make in respect of inherent merit is this. These petitions arise from a concluded impeachment process. In that impeachment process, as you have heard, there were 11 grounds for impeachment. From those 11 grounds, the Senate rejected 6 and confirmed 5. Out of those 5, 3 grounds, and those are grounds 1, ground 5, and ground 6, turned on the conversation or the issue that has come to be known as the shareholder narrative. Now, the first petitioner does not deny that he said those things that he is alleged to have said. It is my submission that there being no denial as to those utterances from the first petitioner, he acknowledges that he said them. There is an admission from the petitioner that he said those things that he said. Now, those 3 grounds of impeachment flowing from facts that the petitioner has admitted, can there be any inherent merit in a petition that seeks to challenge grounds that he has admitted? Ground 1, ground 5, and ground 6 all flow from the shareholder narrative. It is my submission that there can be no inherent merit in those petitions. The finding by the Senate flows from an admission, and that then takes away the ability of the first petitioner to challenge the Senate's finding. My lords, my lady, I wish to move on to the second ground, or the second issue that you would need to consider when you retire to consider your decision in this matter. And that is the issue of whether the petitions would be rendered nugatory if the conservatory orders that are sought are not granted. And I wish to submit on it with the conjoined issue of what is the appropriate remedy in the circumstances of these petitions. My lords, my ladies, in my preparation for my submissions before you this evening, I came across a pitch of a decision. And I wish to persuade you that the applications before you are for dismissal. And I wish to persuade you by reference to the notices of motion that are before you and to decisions of this court that have been rendered in respect of similar matters. My lords, there is a decision that is in pari materia with this one completely, and I say so for these reasons. The decision, and we have filed it as in a supplementary list of authority, is the decision of the High Court of Kenya in Constitutional Petition number 4 of 2024, Purity Mora Kerira versus the Senate and 8 others. It is a decision of the High Court of Kenya in Nyamira. And it is a decision of your sister, Justice Wilfrida Okoin. We have filed it as a supplementary authority, but I have taken the liberty, because it is important to our submission, to make copies available to the bench, which I wish to just walk you through quickly during my submission. My lords, I submit that that decision is in pari materia with this one for the following reasons. It arises from our impeachment process of the Deputy Governor of Kisii County. As I will demonstrate in a moment, the impeachment was preceded by litigation. The impeachment of the first petitioner in this matter was preceded by no less than 29 petitions. My lords, in that matter, a conservatory order was issued in a petition brought by a surrogate litigant. And perhaps I might want to explain what I mean by a surrogate litigant. Our Constitution enables constitutional litigation by a person other than the direct beneficiary of the orders sought. And for the purposes of my submission, I seek your Lordship's permission to refer to that sort of litigation as surrogate litigation. In this matter, a conservatory order is issued in a petition filed by a surrogate litigant. subsequent to the impeachment of the Deputy Governor of Kisii by the County Assembly of Kisii, the matters are then, or the various matters are then directed through the office of the Principal Judge to Lady Justice Wilfrida Okwany, sitting in Nyamira. And Lady Justice Okwany is then faced with an application such as the one before this court this evening, where a party who has obtained ex parte conservatory orders wishes to persuade the court to confirm those orders. My Lord, I wish to start my reference to this decision in paragraph 63 of that decision. Paragraph 63 is to be found on page 17, and in her usual succinct style, Lady Justice Okwany holds as follows. My attention is drawn to the use of the term "and" in the above cited decision, which connotes that the parameters set for the granting of conservatory orders are to be considered conjunctively and not disjunctively. The decision she's referring to is the decision of Wilson Kibera versus the Judges and Magistrates Vetting Board. It is in paragraph 62, and it sets out the criteria for the grant of a conservatory order. She goes on to conclude in paragraph 63. This means that the failure to satisfy one parameter leads to the collapse of the entire application for the failure to meet the threshold set for granting of conservatory orders, and is used between the threshold issue, between the issue of inherent merit and nugatory. We have submitted sufficiently on the issue of inherent merit. I will not add to it. I will leave it to your lordships and your ladyship to decide. But I wish to state that in the petition before you, the petition would not be rendered nugatory if the conservatory orders sought were not granted. And I wish to commence that submission by reference to the notices of motion themselves. The first notice of motion I wish to refer the members of the court to is the notice of motion in petition 565 of 2024, where the first petitioner, the deputy or the former Deputy President of the Republic of Kenya, is the petitioner. My learned colleague, Mr. Gumbo, has gone through the prayers that are spent and those that are live. But I want to focus on prayer 6 and prayer 7. Prayer 6 and prayer 7 of the notice of motion. Prayer 6 reads, pending the hearing and determination of the petition, a conservatory order be issued staying the effect, implementation in any way, including by gazettement and by any person, of the vote resolution made by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. Prayer 7 says, pending the hearing and determination of the petition, a conservatory order be issued staying the implementation in any way, including by way of transmission to the National Assembly or the President of the or to the President of the Republic of Kenya, the vote/resolution passed by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. My lords, my ladies, I wish to refer you now to the other notice of motion before you. That is the notice of motion in petition number 15 from Kerugoya. And I wish to refer you to prayer D in that notice of motion. Prayer D in that notice of motion reads as follows. Pending the hearing and determination of this petition, this honorable court be pleased to issue a conservatory order staying the implementation of the resolution passed by the Senate and published by Gazette Notice number 13,400 on the 17th of October 2024, removing the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, from office by way of impeachment. Those three prayers seek to stay the impeachment. Mr. Gumbo has submitted about the effect of the impeachment. I wish to refer you now to the finding of your sister, Lady Justice Wilfrida Okwany, in respect to those sort of prayers. My lords, paragraph 71 of Justice Okwany's decision reads as follows. In the instant case, I note that the impugned impeachment process has already gone full circle, has been concluded, and a final resolution made by the Senate to impeach the 9th respondent. And again, here the deputy governor was the 9th respondent, and the petitioner was the surrogate respondent. 9th respondent, as at the time the instant petition was filed. It is instructive to note that the impeachment proceeded despite spirited attempts by the 9th respondent to stop the process through applications made in similar petitions that are still pending before various courts. That is not too dissimilar to this, and those are the petitions that are before you under the first cohort, petition 522. Paragraph 72. The question which arises is if this court can issue orders whose effect will be to stay the decision by the Senate to impeach the 9th respondent pending the hearing and determination of the petition. My finding is that since the Senate has already made a resolution, the court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with other organ/arm of government in exercise of its mandate. My lords, my ladies, in respect of the 2 prayers, or the 3 prayers that I have highlighted, I urge you strongly to adopt the same finding as Lady Justice Okwany in paragraphs 71 and 72. My lords, my ladies, Lady Justice Okwany then goes on substantively to deal with the consideration on the second ground of nugatory. In paragraph 73, she states, the other pertinent question is whether the instant petition will be rendered nugatory or worthless if the orders sought in the first application are not granted. Now, she then begins to reflect on the nugatory consideration. My lord, in paragraph 74, she states, the answer to the above question is to the negative. And she starts straight from the beginning by saying no. I find that the applicant's claim that the petition will be rendered nugatory to be misconceived and unfounded. My finding is informed by 3 main issues. And she goes on. Firstly, the applicant's petition is still pending for hearing and is therefore possible that the court may, after hearing the petition, arrive at a finding that the impeachment process was flawed. Very much like in this matter. She goes on. In such any eventuality, the court may grant the petitioner, and indeed the 9th respondent, various remedies including, and this is important, compensation for wrongful removal or reinstatement. Compensation for wrongful removal. One of my learned colleagues suggested that compensation or 1 month's salary is a remedy. That is a remedy as confirmed by your sister, Lady Justice Okwany. And she also states that reinstatement is possible. She goes on. I find guidance in the decision in Mohammed and 6 others versus the County Assembly of Wajir. This is the decision called the Wajir decision, where the court ordered for the reinstatement of the governor who had gone through the entire impeachment process up to the Senate. The court rendered itself thus, and this finding is important, and I submit that when you retire to consider your decision in this matter, go through the Wajir decision and see the entire raft of relief that 3-judge bench sitting in Meru did. And the relief was as follows. As appropriate consequential relief, an order of mandatory injunction is granted against the 8th respondent, Ahmed Ali Mukhtar. This was the deputy governor who had been sworn in as governor after the impeachment of the governor, compelling him to hand over and restore the office of governor of the county of Wajir to the 7th petitioner, Ambassador Muhammad Abdi Mahmoud. That is the appropriate remedy. And I had stated at the beginning that a conservatory order is given for the benefit of the court, not for any party. And if the court then has that ability, then there is no need, I submit, to then issue a conservatory order. My Lord, to explain herself further, I refer you to paragraph 77 of that decision. Lady Justice Okwany states as follows. She states that this court takes the view that an impeachment process can be likened to an election process where, for example, a governor and his deputy are elected by majority votes. Following such an election, the will of the majority voters prevails, and is acted upon within the timelines set under law. This is done through the gazettement and swearing in of the deputy governor, and his deputy, within the set timelines, irrespective of the existence of a petition challenging. In other words, the outcome of an election cannot be stayed through a conservatory order. Suffice it to say that if at the conclusion of the election, petition challenging such an election, the election court finds that the election process was marred with irregularities, then the election will be nullified and the aggrieved party granted suitable reliefs. Importantly, in paragraph 78, overleaf, in similar fashion, and as I have already stated in this ruling, if upon hearing the merits of the instant petition, this court finds in favor of the petitioner, then the ninth respondent will get appropriate remedies, which may include reinstatement to his position of deputy governor, as was held in the Wajir case. And I urge you to substitute deputy governor with deputy president. There is no difference in the position. He is a deputy to an executive office created under the Constitution. She concludes, I am therefore not persuaded that the instant petition will be rendered nugatory unless the conservatory orders granted, sought are granted to the first applicant. My Lord, this is the same as in this matter. There are effective remedies. There is reinstatement. There is damages. My Lord, reflecting further on the issue, in paragraph 79, the last sentence, or the second last sentence beginning on the third line from the bottom, Lady Justice Okwany says the following: I further find that since the office of deputy governor is a public office, it does not belong to a specific individual. It follows that once the office holder is impeached, he has to give room to the next office holder, unless and until such impeachment is overturned or nullified by an order of the court. There is no difference in this matter. The office of deputy president is an office in the public service. It has been submitted that it is a trust. It does not belong to, there is no right post-impeachment that the first petitioner can claim to that office. But profoundly, in paragraph 80, she concludes as follows: I find that in the circumstances of this case, the rights / interests of the people of Kisii, I urge the court to read the people of Kenya, to be represented and served by a duly appointed deputy president. Read deputy governor, read deputy president, following the ninth respondent's impeachment, far outweighs the prejudice, if any, that the applicant herein will suffer if the orders sought in her application are not granted. My lords, my ladies, at this juncture, I wish to refer you to prayers 8 and 9 in the notice of motion in petition E565 and prayer E in the notice of motion in petition E015. Prayer 9 says, pending the hearing and determination of the petition, a conservatory order staying the President of the Republic of Kenya, His Excellency William S. Ruto, from nomination of a person to fill the vacancy in the office of Deputy President. And 8, pending the hearing and determination of the petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of the person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William S. Ruto, to fill the vacancy in the office of Deputy President of the Republic of Kenya. Prayer E in the notice of motion from Kerugoya is the same. In light of the findings of your sister, Lady Justice Okwany, in paragraph 79 and 80 of her decision, I submit that those prayers are untenable. To express myself slightly differently from Lady Justice Okwany, what she acknowledges in paragraph 78 and 79 of that decision is the public interest. The third limb of the considerations that you would need to consider when you retire to consider this decision. It is not in the public interest for somebody who has been impeached to come to court, for the court to maintain a vacancy in that public office pending the hearing and determination of a petition challenging their impeachment. That is quite apart, my lords, my ladies, from the fact that this court can fashion appropriate remedies. It is not in the public interest. As recognized by your sister, Lady Justice Okwany, the people of Kenya have an overwhelming right to have that office of Deputy President occupied during the pendency of the first petitioner's challenge of his impeachment before you. And that right is acknowledged as being infinitely larger than any prejudice that may be occasioned to the first petitioner if that office is filled. My lords, my ladies, there was a submission that it would be impossible to remove a deputy president if he is sworn in because of an immunity that is enjoyed under the Constitution. I believe that the immunity under, I believe it is Article 143 of the Constitution, is to the president only. And I submit, my lords, my ladies, that it is possible for the orders of this court to be efficacious without reference to the president. Mr. Muthomi's client is and remains amenable to the orders of this court, and that remains so even if he ascends to the high office of Deputy President of the Republic of Kenya. My lords, my ladies, the conclusion of your sister, Lady Justice Okwany, and I wish to conclude just by referring you to paragraph 82 of her decision, where she says, flowing from the above advisory opinion, and she is quoting the advisory opinion of the Supreme Court in the Speaker of the County Assembly of Embu. And because we are acknowledging matters that we argued, I must acknowledge that I did argue that matter. Quoting that advisory opinion, she says, I find that the moment the Senate made the resolution to impeach the 9th respondent, the office of Deputy Governor immediately became vacant, that setting the stage for the filling of the vacancy within the stipulated timelines. My finding is that the public interest in this case supports compliance with the constitutional and statutory timelines set for the filling of the vacancy in the office of Deputy President, Deputy Governor of Kisii County. There is an argument that has been made by the petitioners that the Constitution creates a timeline of 74 days for concluding the process. The Constitution, yes, does provide 74 days, but there is nothing wrong with concluding the process in a faster time frame than 74 days. Nobody has suggested that that is unconstitutional. Nobody has, other than expressing, surprise as to the speed at which it happens, nobody has said what's wrong with it. Going by the finding of Lady Justice Okwany, I trust that I have persuaded you that the 2 notices of motion before you this evening are for dismissal. They should be dismissed, and you should then enable the public interest and the people of Kenya to then have a deputy president as entitled by their constitution. I am most obliged. I will take my seat unless my lords, my ladies have anything you wish me to clarify.
Thank you. How many people do you have?
Yes, my lord.
5 minutes now.
My lord, I am taking the least minimum the time, and I believe there are 2 more from our side to answer your question.
3 plus 5. Continue. Finish 5 minutes. 5 minutes.
My lord, there are 2 more.
2 more from this side.
Yeah, 2 more from this side and very short submissions. My lord, allow me to just make 2 crisp points.
There's a need for health break.
Yes, yes.
I am informed.
Okay, my lord.
So we resume 10 minutes time.
Thank you, my lord. Thank you.
Yeah?
It's
Yes. I think we have 4, not 2. We have Rugara, we have Mahat, we have Nyama, and we have Michelle. Yeah.
But what, this is 5 minutes,
5 minutes, 5 minutes. Yeah.
Okay.
He has to speak with some political question around, which is important.
Thank you, my lord. For the record, my name is Peter Wanyama. I appear for the Senate, and for the completeness of the record, the following documents are the responses. We have 2 replying affidavits filed on 21st of October 2024 in petition E015 and 565. And then we have written submissions which were filed on 28th October 2024. And the Speaker also filed written submissions yesterday. They are all in the system. Allow me to make just some brief remarks to highlight our points in addition to what my colleagues have said. I will start first of all by stating that if you examine the provisions of Article 23 of the Constitution, 23.3, the grant of conservatory orders envisions the exercise of discretion by this court. It is the discretionary remedy. It's a remedy which is not available as a matter of right. The petitioner must lay before court sufficient material in accordance with the threshold which has been laid down to, of necessity, lead the court to grant that remedy of conservatory orders. And it is important then at this point to mention the full scope, the third test for the grant of conservatory orders, as contained in the Peter Gatirau Munya case. The third test, this test is deeply erratic. It's also elastic. The test requires the exercise of discretion. So at paragraph 6 of the Peter Gatirau case, the Supreme Court decision, you will find the following words, which are very, very important in our case. And that's the point I wanted to make in the first instance. that the grant of conservatory orders shall be guided by the inherent merits of the case, bearing in mind the public interest. Public interest has been argued by my colleague. I don't need to repeat it. The constitutional values and the proportionate magnitude and priority levels attributed to the relevant causes. That is where I want to focus my submission on. The provisions of Article 23 and the paragraph 86 of the Peter Gaterau Munya case are supplemented by the provisions of Rule 3.2 of the Mutunga Rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord, it is a delicate balance. The court will be balancing the scales of justice to grant that remedy for conservatory orders. And there are factors then which you will consider when you are balancing the scale for the grant of these conservatory orders. And one of them is that you will have to look at the decision that is being challenged from a prima facie perspective. What is the decision that is being challenged in court? For purpose of laying basis for this doctrine of constitutional, the doctrine of proportionality from a constitutional angle. And then that will determine whether that remedy for conservatory orders is effective or not. Now, the first petitioner was impeached. The first petitioner was impeached on 5 major grounds. That is important for you to determine the effectiveness of the remedy and the prima facie case threshold. He was impeached on gross violation of the Constitution. On that limb, there were 3 grounds which were confirmed on gross violation of the Constitution. Secondly, the first petitioner was impeached on the ground that there are serious reasons to believe he's committed crimes under national law. In this case, crimes under the National Cohesion and Integration Act. And the last ground, he was impeached on gross misconduct. Now, in determining the effectiveness of this remedy, the petitioners are arguing that you issue conservatory orders that reinstate this person to office. And our position is that you cannot issue conservatory orders that reinstate this person back to office because of the reasons why he was impeached. So you have to examine the grounds for impeachment. Secondly, what is the decision that is before court? What is the decision that is before court? Have the petitioners amended their notice of motion application to reflect the grounds which they are not happy about? Because, my Lord, we presume, my lady, that they are, of course, not complaining that the Senate dismissed some of the grounds. We presume that they are complaining about the decision of the Senate which is aggrieved to them. So which they are aggrieved to. So, my Lord, if you look at the motion, you will find particulars of matters which relate to allegations which the Senate dismissed. And they are laying that as a basis for the grant of conservatory orders. You will find dominantly material with respect to ground number 7, which the Senate dismissed. Then they are saying that is a basis for the grant of conservatory orders. And we are saying, my Lord, to that extent, they have not completed the test in terms of putting an arguable case in court. They ought to have amended their pleadings to reflect the correct complaint which they have before court and which they ought to lay before court. Secondly, thirdly, in determining the threshold, in determining the agreeability threshold, I just need to mention two decisions from the Supreme Court that you will have to consider. In determining whether they have a prima facie case, you will, of necessity, look at the decision of the Sonko, the Sonko judgment that has been famously described as the Sonko judgment. Now, this Sonko judgment contains principles when it comes to the threshold for all these three grounds that the Senate found to have been confirmed. So for purpose of determining an arguable case, the petitioners have not been granular. They have not complained for purpose of laying a basis with respect to these grounds on why, for example, when it comes to the question of threshold, are they complaining that these grounds don't meet the constitutional threshold? So I invite you to look at the case of Munya as well. And lastly, on the question of the ground of conservatory orders, the Kariuki Mate decision. There is a reason why the Supreme Court, in the Justice Kariuki Mate case, has asked the High Court to apply the doctrine of judicial restraint in granting ex parte orders. And we are arguing that if you look at that decision again, the same reasons why the Supreme Court informed the court not to grant conservatory orders with respect to active parliamentary proceedings. Those same reasons are available when you are determining the effectiveness of the remedy of conservatory orders. And it's our firm submission here that conservatory orders, if you look at the four corners of the Constitution, the provisions of Article 23, should not be granted in a manner that reinstates the impeached deputy president back to office. Because then what will be the purposes of granting that conservatory orders? He goes back to office, he's been impeached for violating national values and principles of governance. So where does the test lead to? We submit that the remedy for the grant of conservatory orders that reinstate is not available to them. The reason is that conservatory orders is a highly and ineffective remedy. Conservatory orders will mean then that this court intervenes on matters which are dominantly political. And in the Munya decision, there is a finding that you cannot intervene on matters which the Supreme Court has stated are supposed to be properly before the other arms of Parliament. It is only the Senate and the National Assembly, as it were in the first instance, that can determine the question of impeachment. Impeachment is about policy, political accountability, and governance responsibility. So to that extent, I wish to submit that the petitioners have not, in terms of the effectiveness of this remedy, laid before court enough material. And I wish to stop there and ask my colleague Mishemi to complete our other parts of the submission. Thank you.
My lords and my lady, my name is Michael Mushemi, appearing for the 9th respondent. On our part, we rely on two affidavits, one sworn on the 22nd of October, a supplementary affidavit sworn on the 27th of October, and submissions and list of authorities dated 27th of October. My lords and my lady, permit me to address you on two critical issues. One is the issue of public interest, and the second is the legal theory of realism as to why conservatory orders cannot issue, especially as to sustain the first petitioner in office as deputy president. On the first issue of public interest, my lords and my lady, you have been told this morning by the petitioners that the office of the Deputy President can remain vacant for a period of even up to 60 days because there is no function that would not take place in government. It is our submission first, my lords and my lady, that the Deputy President is mandated to chair the Intergovernmental Budget and Economic Council, which is created by Article 6, subsection 2 of the Constitution and Section 187 of the Public Finance Management Act. And the Intergovernmental Budget and Economic Council coordinates government policies, legislation, and functions as between the national and county government. My lords and my lady, the law prescribes that the chair and convener of this council can only be the Deputy President. There is no other person in law that can convene the Intergovernmental Budget and Economic Council. Secondly, my lords and my lady, under Article 240 of the Constitution, there is established the National Security Council. And one of the members of the National Security Council is the Deputy President. And it is our submission that pursuant to Article 240 of the Constitution, there is no other person or holder of any other office who can substitute the Deputy President as a member of the National Security Council. This is important, my lords and my lady, because the National Security Council exercises supervisory control over national security organs. This is a critical function of the state. In the absence of the Deputy President, there is legitimate reason to believe that the National Security Council is not properly constituted. And again, this is important, my lords and my lady, because if you look at Article 240, subsection 8, the Council may, with the approval of Parliament, deploy national forces outside Kenya for either regional or international peace support operations or other support operations. So that the situation subsisting as at today, my lords and my lady, is that the National Security Council cannot deploy any national forces either for support operations within the country or international peace support operations. And I urge and respectfully submit to this court to take judicial notice that officers from the National Police Service are currently deployed in Haiti to support with peace operations. So that the argument by the petitioners that the office of the Deputy President can continue to remain vacant is not available because these two critical functions provided by the Constitution and law would not effectively be carried out. On the second issue, my lords and my lady, I invite you to look at Article 3 and Article 4 of the Constitution, and particularly Article 4, subsection 2, which states that the Republic of Kenya shall be a multi-party democratic state founded on the national values and principles of governance referred to in Article 10. The words used in this section are shall, which is mandatory, and the first petitioner avers in his supplementary affidavit, and I wish to draw your attention to his supplementary affidavit in paragraph 17. That is a supplementary affidavit dated the 27th of October 2024. And on oath, he avers on paragraph 17 that I observe that in other open and democratic societies, and he goes on to say, unlike Kenya. So the first petitioner is averring on oath that Kenya is neither an open nor a democratic society. That is his own affidavit. It is our submission that conservatory orders would militate against legal realism to reinstate a person who cannot safeguard the oath he took as deputy president, safeguard the constitution, and who avers in open public that this country is not a democratic society. My lords and my lady, I also invite you to look at Article 130 and Article 131 of the Constitution, which provides that the head of state, the president is the head of state, and the deputy president deputizes him. And in the authority of the president as provided in Article 131, particularly subsection 2C and D, is to promote and enhance the unity of the nation and to promote respect for the diversity of the people and communities of Kenya. It is our humble submission that any grant of conservatory orders that would sustain the first petitioner in the office of deputy president would be a violation of this article. It would also be a violation of Article 147, which provides that the deputy president is the principal assistant to the president and shall deputize the president in execution of his functions. And why this is important is because in the supplementary affidavit dated the 27th of October, we have deponed, or the 9th respondent has deponed, and particularly in paragraph 16, several averments by the first petitioner in which he infers that the president is responsible and must be held to account if anything happens to him. And I will not indicate the rest. You will find them in the supplementary affidavit. So that, my lords and my lady, pursuant to Article 147, it is now no longer tenable that the first petitioner, either at the interlocutory stage or on the final orders of the petitioner, can continue to be the principal assistant to the president. My lords and my lady, I also draw your attention to Executive Order number 1 of 2023, which stipulates that the Deputy President shall chair cabinet committees and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing subcommittees, chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have deponed to in the USA, in South Africa, and Brazil. But of instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you. Thank you very much, my lords and my lady. I want to take 2-3 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and pray that the applications for those conservatory orders be dismissed. My name is George Murigara, appearing with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is sub-article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties nor other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation, in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days, as was even ordered by the court. And after the public participation, there was debate on it in Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be voted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of abundant caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here,
what took place was just a vote. There was no motion because there is no requirement for a motion. There was no debate because there was no requirement for a debate. Because what the law provides is the president nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the president would have to nominate another candidate and continue doing so within a span of 60 days and until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when the Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was in order. It was actually appropriate and cannot be voted in any way, and therefore those conservatory orders should be removed. Thank you very much.
Distinguished members of the bench, Mahat Somane. For the record, I do appear with Dr. Willie Mutubwa and Mr. Hassan Noura for the IEBC. They are all here.
Be present.
Dr. Willie Mutubwa and Mr. Hassan Noura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record,
we hope that we are not sharing the minutes. This 5 minutes.
The Lordship,
no, it's just speaking.
It's just me. We are not sharing. Right. We've decided we will not distribute the time. I will try to cover as much ground as I can on the time allocated. If I need 1 or 2 minutes, you will be kind enough to add me, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, the Lordship, and we have filed and served the same. The Lordship, on preliminary issues, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition, when this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision or the petitioners is an application for their rights in personam, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Peter Gatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the nugatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on 2 grounds. And this is important for the court to note this, on 2 grounds. The first one, the petitioners say that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, Mark Fisher will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC, IEBC cannot play that role. Your Lordship, in Peter Gatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court, because they are supposed to preserve adjudicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it's for your adjudicatory capacity, 2 things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those 2 findings are made, then there is no way the petitioners can establish the nugatory aspect. As it relates to the 2 issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as it relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time. Just like the predicament the court is in, whether it should intervene under 165, we also had that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court said the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important. Supreme Court. The IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the Constitution, look at the Constitution and the statutory law and not get and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client IEBC is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors, for members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the president, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court. We also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail to. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says it says for even members of National Assembly. It says for members of National Assembly, and even in the Elections Act we have that. For an office that is that high, there is, to say that the Constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the WACO draft, Article 159.1, and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the WACO draft for the Supreme Court, and those submissions have been made by Mr. Mudomi Tiankolo.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere with this process, especially I would find there's a role for IEBC. For you to make a finding, for you that the first finding that you have to make there is first the people who hold public office, they hold what we call RETAC relationships. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office. Okay, number one. And that confidence is to the Constitution. Number one, you have to make a finding. There is a property to hold in public office. Okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference. Judicial fear. And we don't do that. Our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference. Not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Gideon Muigai is here. I used to teach first year contract, and the case of Feldhaus versus Binley came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. It's even lower because of that. And look at that decision which we provided to the court. The court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the Constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, of that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is the, Your Lordship, just the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the...
How is it reported?
It is reported as E031. Let me just... It's not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury, Vice Okia Omtata. I argued that matter. I was led by Professor Githu Muigai. Mr. Ochiel Daddy is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic It quoted the case of International Trade Administration Commission versus South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you.
It's basic administration.
It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the negatory aspect, and if you look at the fact that there is at what the submissions of Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
I was being told by Professor Githu Muigai. My professor is telling me to step down. But if I can, just a second. Yeah, not the court, but Professor. But our submissions are those ones. They are on record, and even if there is a role to be played by IEBC, our position is those are administrative roles which we could still play, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register, and we check voters register for even people who, for Kenyans every other day. It's a public document. There is no role for the IEBC to play, and if the court were to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This subsidiary authority you have quoted E031, E033.
I will.
It is hot off the press. I will submit it just now.
Submit to our assistance.
I will, Your Worship. I will. Thank you so much for listening.
My Lord, I want to apologize if I appear to take judicial discretion from you. It was intended to keep my promise to you that we will be brief.
We now get to know that every side has a prefect. This side, the prefect is Professor Githu.
My Lord, just want to also add my voice to the submissions that have been made by the respondents. We should go on record that my name is Shara. I'm also the Solicitor General for the Attorney General, together with Professor Githu Muigai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not in contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we are challenging.
A final order to this, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting that the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been met. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the President, which are currently at a standstill, would be extremely critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you. My Lord, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Okay, two things.
Why are we being preempted?
No, two things on one call. I think we still have to be interested parties, or do we have them?
No,
We did that. We did that. We finished with yes, now, the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have two, and they will have how much do you think?
You have given us 30 minutes. I am addressing the court, please. Yes. Reply to the court. You have given us 30 minutes.
That's okay.
My Lord, do we go 15 or 20?
No, my Lord, there is a lot we can pass. In fact, they have given us the impression that they will read later than now. They have obviously done 4 hours and something. There were things that we can do within 30 minutes, or less, depending on how much is able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business, and we go.
Okay, this is the way forward. We will give the respondents the time, maybe 30 minutes each. Not the respondent, but the applicant. 30, let's go.
I don't, may I please report on the same issue, because I've been standing and I did catch your eye. Still on the issue of the right of reply. My lords, you might remember that I am, first of all, I am one of the represented petitioners of Petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later, not now. And the rejoinder should be on points of law. Rejoinder should be on points of law.
My lord, I stand guided, but I'd still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to the council for the other applicants.
My lord, before our council proceeds, I am Mwangi Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application which we believe we have a right to rejoinder, a brief rejoinder. And it was one of the applications that was canvassed. So we also have a brief right to rejoinder. We'll only take 5 minutes.
My Lord Moraro appeared in person and argued his own case.
And I am his counsel. We are here together with him in this matter.
Let us give directions and we will proceed with these directions which my Lord Judge very much again. There must be order in every proceeding.
Who start together? Mr. Yes, proceed.
My Lord, my name is Uzalendo. It's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is my name. Lord, allow me to begin with where my very good friend Mr. Somane stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry here involved in, extends, the court while conducting this inquiry should bear in mind the unlimited reliefs contemplated under Article 23. And that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubt, the court should now feel comfortable. Now, during the break, I inquired for my learned friend, Mr. Thiankolo, a very good friend of mine, and I asked him, Dr. Thiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
Yes. You want to hear? When I asked him, by what authority? He told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August, 2024, in petition E429 of 2024. Let me come to the other case, the Kisii governor's case. Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that that matter would come before Justice Okwano, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My lord, that case is different from this one on the issue of delay. Under Section 32 of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Mora Kirera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my lord, the need to allow the transitional processes to be disputed. My lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. And allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both of the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petitioner more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wengi Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. Other cases we agree with, cited by the National Assembly's Gitari Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days, all the three chains of Kenyan's court, when required, have risen to the occasion. BBI did not last the 3-5 years my friend Mr. Kiankolu spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Gideon Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Gianda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petition has not pleaded for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Kiankolu bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that What would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IEBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed to reconstitute the IEBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy of conservatory orders in his and his client's favor. My Lord, a party cannot benefit from their own wrongdoing. That fact of vacancy in the IEBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners.
Mr. Dudley,
My Lord,
are there any pending litigation on the IEBC court?
there are, yes, my Lord, but this order has not been stayed, it has not been appealed.
That's okay.
Yes, my Lord. My Lord, there's a case that we did with my good friend Mr. Adrian Kamodo. It's called Itubi versus Law Society of Kenya, where Justice Omudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itubi, through my good friend Adrian Kamodo Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask the Court of Appeal to vacate conservatory orders meant to preserve the status quo pending the hearing of the matter in court. We submit that the application to vacate made before you is an act of mischief. There's another case, my Lord, on this issue of vacating conservatory orders. This case was argued by my good friend Mr. Nyamudi when he was still on the good side of things. And Professor Gideon Rigathi was also in it. Those days, Nyamudi was a good guy. He had not joined the bad company of Mr. Gumbo, who is my friend. This is what the Court of Appeal said. The Court of Appeal said that
Lobby must be a bad guy if Gumbo is bad and his friend.
The Court of Appeal said, my Lord, that when weighty challenges have been placed before you, before a court, and the court has issued conservatory orders, one requires a very strong case to lift those conservatory orders. My Lord, a very strong case has not been made before you to lift the conservatory orders. Instead, a very strong case has been made to sustain and to affirm and to reiterate the conservatory orders. My Lord, I close with the issue of public interest. And again, thanks to the doctrine of precedence, you do not have to think too hard on this. In Attorney General versus Martini, shutting out 50 CISs whose appointment was questioned before the court, the Court of Appeal, my Lord, said that it would be no consolation to tell the Kenyan people that although service has been rendered, although unconstitutional service has been rendered, it's still service. The Court of Appeal said, my Lord, that service in violation of the Constitution is no service. And in a case that Professor Ojenda argued, the Ongo case, when
I didn't cite that.
I am citing it, well, I am citing it in the reply.
In response, although I thought on points of law, you refer to cases that have been cited by the other side.
No, I did not.
You can't pick up my case. I didn't have it.
My Lord, if he didn't argue it, he should have argued it. This is a point. My Lord, you are told about the public interest. The Court of Appeal no more.
I think you cannot argue no more.
Because otherwise he also have the right to yeah, and we'll hear from much better time.
Back and forth. Just leave
If that will help from the law, how we have, for example, presented to you the Supreme Court President? Because the purpose of rejoinder as well, my Lord, is to distinguish and to tell the court points which the other side have concealed.
Well, you say it, then we'll give him a right of
and
reply on that issue.
It's in our submissions.
Do you accept that we'll give him a right of reply on that issue?
For this case, yes, my Lord, because it's in our submissions. The more case is in our submissions, my Lord, and they can distinguish it very shortly. My Lord, the court said, in short, that it is in the public interest to keep out a person if the validity of the appointment is questioned. He had wanted his client to assume office despite a court order to that appointment. And so, my Lord, the office here is a high state office. If Kithure Kindiki assumes office, he will make directives, he will make policies, he will commit omissions. My Lord, this court is yet to design a mechanism for reversing the policies, the decisions, the directives that you will make. If at the end you find that the impeachment and the nomination are both unconstitutional, the Constitution would have been irreparably violated. And my Lord, I close on the point that this case is arguable. In fact, the courts had to stop Mr. Milimani many times and was lenient to many others of my colleagues who strayed into the merits. Prof. Agenda being at the forefront of that. The council argued the merits on both sides of the aisle. And so, my Lord, that demonstrates that parties are biting at the bits. They are ready to argue the petition and will do so as at the earliest opportunity. We request you, my Lord, to allow the request for conservatory orders to please preserve the dispute and let our appearance, our further appearance before you be of some meaning under the Constitution. Thank you for the opportunity, my Lord.
Thank you.
Look, may I donate, if I still have it, 3 minutes to my colleague, Mr. Gachagua.
Lordship, I will be brief. I want to respond to the following points of law raised by the other side. From the other side, a lot of hue and cry has been made about Article 145, Subclause 7, and the word shall. Lordship, the Black's Law Dictionary, Brian Garner, 10th or 9th edition, confers 6 different meanings to the word shall. So from the plain text meaning of the word shall, the dictionary in law gives it 6 meanings. So shall cannot only mean mandatory, it can mean any other thing. Black's Law Dictionary. In terms of the reading of the Constitution, the Constitution can be read multiple times. It's not only the textual reading of the Constitution that counts. If I had time, I would share with my friends that they drink uji once in a while on the other side. There's a book by Professor Philip Chase Bobbitt that canvasses 6 methods of reading the Constitution: textual reading, moral reading, structural reading, doctrinal reading, purposive reading. Purposive reading has been read in our Constitution, Article 259(1). It has about 4 elements. If we go to 259(3), living tree reading, first articulated by the case of Edward versus Sankey, 1930 Canada. What does that mean to this honorable court? There is more coming. So while they were telling us that we are running away from the case, they're telling them, we are ready, and we're going to explore the full depths of this constitution on the merits. Please consult the substratum. We are ready to go. The question, another point was raised here, that the president is protected by the constitution in his role in appointing a prophylactic deputy president in a nominating capacity, normative capacity. The constitution in that manner is deemed as a constitutive charter. It creates institutions. The constitution, going by the violations that have been raised on this side, touching on constitutional rights, plays a protective capacity. So this court will, on the merits, be asked to balance those two shades of the Constitution. The Constitution as a constitutive charter, the Constitution as a protective charter. We will discuss that on the merits. My good friend, Senator Professor Tom Ojenda, expert orders need to be lifted for the reasons he raised. They have not answered to your satisfaction, and we attached a case in our submissions, the decision of the Ghanaian Supreme Court, Barclays Bank, in our submissions, the test for overturning a decision made ex parte. They have not satisfied you as to why the decisions of Justice Mwongo in Kerugwa should be overturned. The issue here is broader than mere compensation by way of sums of money to an individual. The broader question here is the Constitution and how offices of the Constitution are occupied. Article 1, Article 2, Article 3 of the Constitution. My good friend and teacher, Milimani Nkolu, that there is an absence of a specific textual authorization for judicial involvement in the court. Again, we refer to the various methods of reading the Constitution, so that if we go by their own arguments, and I had my good friend Mr. Somani talk of reading in, that's a remedy available to this court under Article 23. Reading in can't be read into statute or any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we were to look at the travaux, the preparatory documents, where are the comments from the delegates? Where is the report of for the Committee of Experts? And in any case, the Constitution 2010 enjoys its imprimatur, its force in law, by the seal of approval it was given by the citizens through a referendum in August 2010. And any law interpreted and read into the Constitution post the promulgation, that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Milimani, the Senate sits in a quasi-judicial capacity. Yes, the Senate sits in a quasi-judicial capacity. Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
My Lord, for purposes of the second application, Mr. Ndegwa will, in about 5 minutes, will make some 2 points, then I will proceed with the remainder.
Thank you very kindly, my Lord Smiley. Permit me just to indicate what Professor Idhu Muigai Senior Counsel indicated, that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is civil appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that preposition, and it came to a conclusion that when the Senate is seized of a matter of impeachment, it's not just a political chamber, but it converts itself into a quasi-judicial process. And that is why, my lords, under starting order number 79, the Senate is required to take a special oath before constituting itself into a quasi-judicial chamber. On the question, one issue of about justiciability of the process, it's our humble submissions, my ladies, my lords, that was ousted by the enactment of Article 3, Article 1, Article 10, 27, 25, 50, 165, and 159 of the Constitution. When the people of the Republic of Kenya enacted Article 3, it bestowed upon all state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution and Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165, 3D, calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution? Was the impeachment of the Deputy President not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that respect? Allow me to address what Professor Ojienda addressed. The question of the two-tier trial. Yes, it was a two-tier trial, but was the Deputy President granted an opportunity to be heard? My lords, my ladies, look at Article 1 and Article 94 of the Constitution as read together. Article 94 provides for the creates Parliament and provides that it's a representation of the people. How can it be a representation of the people and you lock them out when it comes to their participation on a question of the impeachment of the Deputy President? How can it be that Parliament can be immune from the application of Article 1 and usurp the people's power when the people are supposed to directly participate in giving their views under Article 118 of the Constitution? Well, ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 145. My ladies, my lords, the only time Senate was limited was when or if it constituted itself into a special committee. If what transpired in Parliament in the Senate was a matter that was under Article 145, Clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the Deputy President, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you have been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend Professor was candid with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the president and deputy president, standing order number 78, 9, and you'd have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the president chooses to appear before the Senate, the president shall be required within 3 days of the invitation under sub rule 4 or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate, in which the president shall set out. He would have told you the mode of appearance. 1, the president's response to the particulars of the allegations. Number B, how the president, and in this case the deputy president, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the deputy president could have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The deputy president appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this Honorable Court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was candid with the truth, he would have invited this Honorable Court to harmonize and to purposively read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IEBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the President? Is it Mr. Somane? Is it Ndegwa? Who determines that qualifications if it is not the IEBC?
My Lord, there is something that Mr. Giro is submitting on, which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to work for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's contribution and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to.
And secondly,
that's a merit issue that is being argued. So we're going to have the opportunity to answer it, because the law is the opposite of what he's saying.
It was raised by Mr. Giro, just clarifying.
It is not the time to raise that issue. That is my submission, my lord. He is going into the merits.
But then Mr. Giro may
just let's sort it. My lord, it's views on record for Professor Kindiki. I think if Mr. Dewa Giro, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Dewa Giro means. If my friend the Black Bull would keep within the remit of a rejoinder and a reply, will not be having all these interjections. I've been resisting that because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Giro time to...
I am most obliged, my lords. My lords, finally, let us distinguish the Kisii case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to find that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is even today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is replied, issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that unlike in war, where you can change facts on the ground, the court looks, the court does not accept a situation in which one party would be allowed to change facts on the ground in a manner that makes a mockery of the proceedings before it. That is to say, if we are before you on account of the fact that there have been violations in the impeachment process, my Lord, and the conservatory orders that have prevented the completion of those illegalities are in issue, this court should not permit a situation in which a party is able to say that let me change certain facts, as it were, by completing the violations. My Lord, there is a question of public interest. We don't have to say much about it, but coming from the Honorable Attorney General, my Lord, I would only urge that public interest from the Attorney General must also be read, apart from what is directly friendly to the government, must also be read to what is also friendly to the people of Kenya. And that is a desire to ensure that the impeachment process is done credibly and upholding all the rights and the procedures that are in issue, so that it is still possible for the Attorney General to say that public interest in this particular scenario would require that fundamental rights, the case on fundamental rights, be concluded before you can be able to say this or the other person should take office. My Lord, there is the issue of the conservatory orders. I've had to read them again. The one from Justice Muongo, because they have been called as orders of reinstatement or mandatory mandatory injunctions. My Lord, I believe and I have a lot of full confidence in the fact that it will not be possible for Judge Muongo to issue mandatory injunction on reinstatement at that level, and as a matter of fact, he did not. The prayers as framed is purely to preserve this matter pending hearing and determination of the petition. So it's a scarecrow argument to say you are seeking reinstatement, you are seeking mandatory injunction. There is no such thing, my Lord. It is the one of the president. But my Lord, the significant position that I wish to make from that case is this: that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position that it was the desire of the Kenyan people that nothing shall be beyond the reach of the court for purposes of giving redress. And that is the basis upon which we have been proceeding. I will end it up there and come to what he is more comfortable with. Jurisdiction with regard to purported ouster of the jurisdiction of this court with regard to impeachment of the president. My Lord, jurisdiction is actually not given in the manner that they are suggesting. My Lord, even for purposes of the governor, which he says is different, there is no provision under Article, I believe it's 181, that says, or 182, let me just confirm. Yes, my Lord, for purposes of the removal of county government under 181, the issue is none of those procedures actually says that after you are done with impeachment, you will go to the High Court.
May I help parliamentary? As we do in parliament. The impeachment
Professor, this is not parliament. He has not sought your help. Please sit down.
Thank you, my Lord. I know that tactic. But my Lord, the point I'm making is that even for purposes of Article 181 and 182 of the Constitution, there is nowhere that those provisions say that when you are done with impeachment at the Senate, you will go to the High Court. But nonetheless, people have been going to the High Court on account of jurisdiction as set out in Article 165 of the Constitution, the jurisdictions of the High Court. And therefore, my Lord, this requirement that, there is no provisions for going to court, it is neither here nor there. That is not the design of the Constitution. That question of jurisdiction has been settled by specific provisions of the Constitutions. My Lord, what about these issues that you needed to go to the Supreme Court? My Lord, for purposes of the jurisdictions of the Supreme Court, it has been settled very clearly. I believe it is under Article 163, sub-Article 3, and it is settled in a manner that it says in very, very conclusive terms. This is 163. I believe it is 2. It is actually 3 and 4. They completely settle what is within the jurisdiction of the Supreme Court. Their argument that you cannot arrogate jurisdiction would actually come into play in this particular manner if this court were to make a finding that this matter ought to go before the Supreme Court. Because effectively, you would be amending Article 163, 3 and 4 of the Constitution as to the jurisdiction of the Supreme Court. But my Lord, where you find comfort is that the jurisdictions of the High Court, and that's why it is a court of original civil and whatever and criminal jurisdiction, is that the High Court has jurisdictions in everything unless the Constitution says otherwise. And to deal with that, when we come to the Senate, the moment, my Lord, you say the Senate was sitting in a quasi-judicial capacity, It is a design of the constitutions that any person who sits in a quasi-judicial capacity, there is a right to go to the High Court. There is no law in this country, not one, in which any person who sits in a quasi-judicial capacity, there is no remedy to go to the High Court by way of appeal, by way of Article 23, or any other manner. So that issues of jurisdiction is neither here nor there from the plain reading of the Constitution itself. So the other cases of Nixon, all those, they would be neither here nor there as far as we are concerned. Mr. Milimo talked about...
While you are still on that issue.
Yes, my lord.
Dr. Ogada also addressed this, but what is your view on the submissions by Dr. Kinkuli about the constitutional history?
Oh, yes.
That issue.
That's very interesting, my lord. I think I should say something. I was just giving myself additional pressure. My lord, for purposes of that history, and incidentally, as a young lawyer, I was involved in all this process, courtesy of Muite Orengo and Dr. Gibson Kamau Kuria, so I can speak with vast knowledge of some of these issues. My lord, this Boma's draft constitution, you actually find it very interesting. We cannot go deeply into it. Precisely. My lord, the issue that is important to note is that under the Boma's draft constitution, there was, first of all, impeachment was dealt as a justiciable issue, but it was justiciable at the Senate. So the argument that it was non-justiciable cannot be supported by the Boma's draft. And any other constitution that was actually talking about the issue of impeachment being justiciable, either at the High Court level or at any other level. But my lord, the important issue would be how we traveled to the position that we are in today. And my lord, the positions that we are in today, as my learned friend Mr. Ocheli is pointing out, is that when you compare, particularly Boma's draft and the current one, you'd actually see that the jurisdiction of the High Court was actually increased in the 2010 Constitution, and the jurisdiction of the Supreme Court was actually reduced in comparison to what it was under Boma's. So that, my lord, we are in a happy situation that you arrived at a situation whereby the High Court is the main court for purposes of the 20 Constitution, which reinforces the arguments that we made. Democracy in this country fails or succeeds depending mainly on the decisions of the High Court. My lords, I hope I've answered that issue of the history, my lord, because of the usual pressure of time. My lord, Mr. Milimo, I believe he made many points. I will choose one or two. He alleged that nobody is disputing that public participation was carried out properly or anything. My learned colleague, Mr. Sankipa, has pointed out to me that there are actually 5 affidavits that says that, and one of them was actually by Mr. Omoke, the advocate who was here, to say that the process was completely muddled up and they got it wrong. My lord, the only other point that was made when Milimo was speaking was to say that the Speaker has no vote. It is true, we are aware of, all of us, the Speaker has no vote. But my lord, everybody, and is actually the duty in the standing orders and in the Constitution, as a presiding officer in the National Assembly or in the Senate, the Speaker, there is a duty of impartiality. That is where anything you read about the Speaker, they talk about that. The duty of impartiality for purposes of the Speaker. For purposes of both speakers, my lord, they made the rules of impeachment. Those rules are the subject matter of what is going on. How you will carry out public participation, the calls that were made, is it going to be plenary, is it going to be committee? The most important one being, you could have held these proceedings until Sunday, you decided to read the rules to allow people to vote on issue of rights. My Lord, my knowledge of and Article 27 of the Constitution, matters of rights are not subjected to votes. Yet that is what happened at the Senate. So that's an issue that we shall be talking about when we comes to the hearing of the petition. So the Speaker is not a nobody. The Speaker, and for purposes of these proceedings as they happened, all those speakers, they made consequential decisions that have had serious implications in the matters that is before you. Mr. Gumbo, my learned colleagues, he says very many useful things. You wonder what to choose, what to leave. One of the issues that he said that is when he talked about prayer number C, the prayers that was granted, is to say very unsustainably that the only arguable thing is on the swearing in. My Lords, all those prayers were supporting a petition that is seeking at the conservatory stage to stop the impeachment process in a manner that preserves the subject matter of this matter. This is what we are arguing today, and my Lord, consider the issue on merits and make the relevant decisions. My Lord, he says that it is not tenable for this court to stop it. My Lord, that is exactly what these courts have been doing from all these many cases that have been cited. That in appropriate cases, decisions are made in a manner that upholds justice. The duty to do justice is an absolutely important one. You are told that Gachagua cannot be able to hold office because of Article 73(1) of the Constitution. That, of course, will be the case when he reaches the end of the road in these proceedings. End of the road will be Supreme Court, I am sure. But as of now, that issue does not arise. My Lord, as regards the issue of Article 148 to 149, I think we have said a lot about it, except, my Lord, when it is alleged that public participation under Article 149 is not required. My Lord, the issue is this. The Constitution is clear that from Article 10, it says whenever you are interpreting or applying the law, the values and principles in Article 10, which includes public participation, shall apply. What that means, if Parliament is carrying out a constitutional duty and Article 10 applies, unless it is excused by anybody, which I don't think it is possible, then prima facie, one cannot argue that public participation is not required. My Lord, the same argument would also follow under Article 118. It talks about legislative business and any other business before Parliament, which is exactly the issue about Article 149. Public participations would be required. So that, my Lord, prima facie, we are asking the court to hold, for purposes of the issues that will come for the petition, that prima facie, public participation that was supposed to be conducted for purposes of Article 149(1) were not conducted. My Lord, coming to the issue of public interest, legitimate expectation that the positions be filled, I agree. But the law also must be followed in filling vacancies in public positions. That matter has been rehashed in very many, including in a case which we have cited, where a representative of the public to the Judicial Service Commission was involved. And the bench of this court was categorical, public participation was required. It would be the same thing when it comes to a person who is nominated, not elected, that such public participation be conducted. My Lord, when it comes now to...
My Lord, for purposes of information to the court, it is worth noting that the Supreme Court decision that has been read today has actually rendered almost obsolete all the previous arguments of the applicants. Just for me.
Do they say Article 118 of the Constitution requiring public participation is deleted from the Constitution.
My Lord, I hope his information will serve its purpose. My Lord,
I think you need to answer Senior Counsel's question.
It's actually, that decision will actually reverberate through all cases that touch on public participation. It has shattering, and we are happy that God has brought it at this time to us. So God is on our side.
My Lord, I wonder now whether it is Gumbo who was talking about Roscoe Pound. Is it you? Somebody was talking about Roscoe Pound. My Lord, I agree with Roscoe Pound, one of my favorite legal philosophers, when he talked about the issues of law as a tool of social engineering. And my Lord, the Constitution of Kenya is actually an important tool following the doctrines of Roscoe Pound as an important tool of societal transformation, as Dr. Willie Mutunga, CJ Emeritus, said in one of the famous decisions. And therefore, I would not agree with him more. And my Lord, I would only point out to the fact that in following Roscoe's Pound, it is a reason why we have Article 10 on the ethics and principles of governance. It is a reason why we also have Article 259 of the Constitution that says how you are going to interpret the Constitution's rule of law, values, Bill of Rights, all these things are mentioned. So I agree with him that the Roscoe's Pound is actually codified for purposes of the Constitution of Kenya. And my Lord, that is something that you must bear in mind, that constitutional litigation in this case is a value-based system. It is not any other different. My Lord, on Paul Nyamodi, I believe we are not engaging in any merit review, and therefore there is nothing much to say about what he was saying. But my Lord, the only important issue that we would like to say is that Article 23 actually says that amongst the relief that can be given when one is seeking to enforce fundamental rights under Article 22 of the Constitution are these orders. One of them is conservatory orders. So that is also an important issue to bear in mind. And my Lord, the final point that I wish to make a note, because there were no other points, is to point out the fact that the old favorite case for most of us that we had pointed out to answer the other global issues that have been made, to emphasize the issue of justice. My Lord, in the Githunguri case, the deciding point was this. It was not that Githunguri was an innocent man. They made it that very clear. Githunguri could as well have been guilty for the offense that he committed. But what moved the court was to say, the Attorney General cannot say today, we shall not prosecute, you go back, sit pretty, forget about answering any questions, and then you are called upon at some other stage by another Attorney General kuambio kufungulio mashtaka upya. What they say, to use their precise words, is that a prosecution is bad at the start, not at the end. My Lord, in this particular case, we are saying that the manner in which these impeachment proceedings have been carried out, it has been carried out, as we have tried to demonstrate, badly from the start during the process. I urge the court to ensure that this bad process is arrested. Even when we did not have a serious constitutions to preserve those kind of due process rights, which are what we are here to process, Justice Madan protected the due process under the law. During our circumstances, arguing in October 2024, there is a constitution that says in no less than 10 articles that in doing substantial justice, a certain way of doing things is the only way to do it. If we were to say that it was possible to do due process in 1986, how much more can the High Court do? Your Lordships and my lady, I urge you to confirm the conservatory order and to dismiss the applications to seek their setting aside. I am most obliged.
my ladies, my lords, only one point that my learned friend has escaped his mind is the submission of Mr. Milimo, that the Senate, sitting as a quasi-judicial process, cannot then engage in public participation under Article 118. That's a misconception, because the Senate sits as a quasi-judicial process when it sits to listen and to hear the case. The presiding period in the preparation of the hearing of the case is when they are supposed to commence public participation. And the concept of quasi-judicial process does not oust the constitutional obligation under Article 118 to conduct public participation.
Yes. Yeah, whether you had made a judicial promise that I would respond to Mr. Chair.
He did not follow it.
No, he did. He made submissions on the case of Samuel Ngou, and you indicated, my Lord, that I would make a response. I'll do that in 1 minute. My Lord, the case of Samuel Ngou versus Alpha related to a gazettement. I'm just distinguishing the case. A gazettement of one of the 9 members of the board of Alpha. The court initially granting a stay, my Lord, because the initial stay did not, consultative order did not affect the functioning of the board. And there was a subsequent gazettement because he had been nominated by 2 organizations. My Lord, the distinction here is that the position of the Deputy President is in a unique position as defined by Articles 130 and 131 of the Constitution. Therefore, that case will not apply. There are many board members, about 8. This is a single position. Does not apply. As distinguished, my Lord, as the impeachment of the Deputy President under Article 145 and the impeachment of a governor under Article 181 and Section 33 of the County Government Act, which is statutorily underpinned. Very distinguishable. All the cases they have cited are irrelevant on governors. The impeachment of a Deputy President is unique and is final under 145(7) because it is constitutionally underpinned and not statutorily underpinned. You can't object or finished. That's all.
My Lord, with tremendous respect to the court, we have had the opposition from the other side on our right to rejoinder, but we would like a court to pronounce itself, because the record will reflect our representation from when the case was transferred from Eldoret to this court has never changed. The law firm Mr. Murara arrests in is the same law firm that we work and filed this petition under. And this is not a new thing. Even in the BBI case, Mr. Murara was a petitioner and appeared with the council.
What is the issue?
It's the right to rejoinder. We have not been given an opportunity.
Hello, do you have something to say on that? In the petition which Mr. Murara filed in Eldoret, he filed a petition in person. Today he appeared in this court and urged certain points in person. There are certain matters which he made, and even the professor raised an issue seeking to cross-examine him. And then it turned out that he appears in person. So we need a notice of change.
There is no
notice of appointment of advocate for now Murara to instruct counsel to represent him in these proceedings. That is the extent of my objection.
I thought, my Lord, you ruled on it unless you're being asked to revisit your ruling.
You have notice of appointment.
My Lord, there is no need for a notice of appointment. The record will reflect that the firm, the pleadings are not filed by Murara in person. They are filed by the law firm. And Mr. Tiankolu also appeared with Murara in fact, with the BBI matter. So I don't understand why he would object now that the case went up to the Supreme Court. I only request for 5 minutes.
I think we have come to the end.
of today's proceedings. We want to take this opportunity to thank you all, council who have presented their plans, cases, and even people who came to see the proceedings. We have sat until late. We shall render our ruling on Thursday at 2:30. Thursday is Tuesday. A day after tomorrow, 31st at 2:30.
My lords, perhaps I need your guidance because we indicated in the morning that we have an application for contempt of court, for which
Mr. Ndegwa, listen to the instructions and directions of court. We will give a ruling on this matter on Thursday the 31st at 2:30. After that, we'll provide a way forward for any other matter. Thank you.
I want to go.
Please sit down.
Yes, that's it.
So we see you on Thursday.
This is not tomorrow.
No, that's very good. It will be hard on Thursday. Now we have to tell them they can arrest the judge.
The judge, Oh, Chair, thanks. It was good,
These students online assistants.